in this matter is due to the filing of case 24-DM-309 in the matter of Benjamin Bravo Hernandez and Monica O'Rourke Bravo. I will also note for the record that there is a California case which preceded the filing of the Kansas case. There have been 2 conferences under the UCCJEA conducted by this court with different judges of the Fresno County Superior Court in California. It was determined after the last conference with Judge Allen Hill that it was going to be necessary for the California court to determine whether California has now become an inconvenient forum, therefore allowing transfer of child custody jurisdiction in parenting matters to the state of Kansas. I will just point out to the parties in this case that the decision to be made today is really solely on that issue as to whether California is now an inconvenient forum to continue child custody proceedings there. While this court obviously has a continuing interest in the outcome here, the Kansas court will not be deciding this. This is solely a determination to be made by Judge Allen Hill on behalf of the Fresno County, California court. So with these things stated, I'm going to go ahead and turn things over to Judge Allen Hill from the Fresno County Superior Court, and she can conduct further proceedings.
Thank you, Judge. This is case number 18 CEFL 04557, the matter of Benjamin Bravo Hernandez and Monica O'Rourke Bravo. Ms. O'Rourke, there is a dissolution in this matter. Did you go back with your maiden name, or are you keeping the name Bravo?
I have the legal name of O'Rourke Bravo as my last name.
And so that's what we will call you then, O'Rourke Bravo. And you are represented by counsel. If counsel could please state appearance for the record.
Good afternoon, Your Honor. Brian Fallon, appearing on behalf of Monica O'Rourke Bravo. She is present via Zoom.
And Mr. Bravo, you are not represented by counsel in either state, is that correct?
That's correct.
It will be this court's intention to proceed pursuant to Family Code Section 3427. That's California Family Code Section 3427, which indicates that the California court can decline jurisdiction or transfer jurisdiction in a child custody case if it determines that it is an inconvenient form, and that another state is a more appropriate form for hearing the matter. Before the court makes that determination, the court shall hear from the other parties. That's what the law says. And the court has to consider 8 factors.
The judge lays out the case, framing a battle that could shift everything.
In Family Code Section 3427. Mr. Fallon, you're aware of what those 8 factors are. Is that correct, counsel?
Yes, Your Honor.
And Mr. Bravo, are you aware of what those 8 factors are?
No, I am not.
And so you've had other conferences with the UCCJEA, and are you familiar with Family Code Section 3427?
Not at all.
And so you understand that today is the day that we have set aside for this court to determine whether it is an inconvenient form. Are you ready to proceed on that issue?
I'm not. I haven't been. I don't really want the jurisdiction to be changed, but.
So you understand today is the day that you are to present information to the court to tell the court whether it should or should not find that it's an inconvenient form. Mr. Fallon will also present information to the court, and then the court will make a determination. You understand that?
Correct.
And are you ready to proceed today, sir?
We can proceed. That's fine.
And Mr. Fallon, are you ready to proceed today?
Yes, Your Honor.
And so I don't know what you might have available to you, Mr. Bravo, whether or not you can have a device where you can look at Family Code Section 3427, but I will tell you in advance what those factors are, and if you have a device and you can pull up that code section, it will set forth those factors. The court has to consider whether domestic violence has occurred and is likely to continue in the future, and which state could best protect the parties and the child. The length of time the child, and I know there are children here, the length of time that the child has resided outside of this state, California, the distance between the court in this state and the court in the state that would assume jurisdiction, that would be Kansas, the degree of financial hardship to the parties in litigating in one form over the other, any agreement of the parties as to which state should assume jurisdiction, the nature and location of the evidence required to resolve any pending litigation, including the testimony of the child, the ability of the court of each state to consider the issue expeditiously and the procedures necessary to present evidence, and the familiarity of the court of each state with the facts and issues in the pending litigation. Let me first ask, is there an agreement, and I think I heard you say, Mr. Bravo, you did not want the case to transfer jurisdiction. Mr. Fallon, are you aware of any agreement for a transfer or for the case remaining in California?
No, Your Honor.
And Mr. Fallon, it's my understanding it is your client's request to have the case transfer to Kansas. Is that correct?
That's correct, Your Honor.
With regard to any pending litigation, it is my understanding, and I was not the judge hearing the matter, and certainly I apologize on behalf of the County of Fresno, State of California, we have had a movement in our family law judges. That's been a positive movement because we have now more judges assigned to family law than we've ever had in the past. But because of that movement, cases had to move. And that's why I'm the third judge to hear this issue or to consider this issue. I'm not sure that there's been a full hearing previously, but certainly 2 other judges did consider the issue. Additionally, there was a custody and visitation litigation and litigation with regard to Family Code Section 3044. That's California's Family Code section that says if there were previously or now a finding of domestic violence, then there is a presumption that the perpetrator of domestic violence not have sole custody, joint custody, either physical or legal. There has been a hearing. A court has found that Mr. Bravo has rebutted that presumption, and there is a custody and visitation order that was signed and filed on June 20th of 2025, granting mother sole legal custody and the parties joint physical custody with a visitation parenting time schedule and some standard findings with regard to safety and protection. There's also orders for individual counseling. It is a full custody order. That issue is no longer before the court, and when I look at the file, I find that there is no pending litigation. Mr. Fallon, would you agree with that?
Completely.
Mr. Bravo, you agree that there's no pending litigation, sir?
Correct. But I was trying to get in some court paperwork for this last violation of custody orders. So it'll be in the courtroom here pretty soon.
But you have not filed anything with this court since the
today,
June 20th finding.
Right.
So there is, at this time, no pending litigation, although you indicate that there might be soon.
Correct.
With regard to the court making a finding of inconvenient form, it would be Mr. Fallon's responsibility on behalf of Ms. O'Rourke Bravo to come forward with the evidence first. Then, Mr. Bravo, you could respond to anything that Mr. Fallon provided, and then Mr. Fallon would have the last opportunity to respond and argue to the court. You understand that procedure, Mr. Bravo?
Yeah.
Are you in agreement with proceeding in that fashion, sir?
Not necessarily, because I feel like it's at a disadvantage to let the attorney go last.
So whoever goes first goes last. So
Okay.
that's
Oh,
because they
okay.
get just one second. They get an opportunity to respond to the other party. So if you're asking that you go first, it is really Ms. O'Rourke's request to transfer jurisdiction. But if you're asking that you go first, I'll hear from counsel as to whether or not he's in agreement with that. Is that what you're asking, Mr. Bravo?
No, I was just making the statement because you said that he would go first and then I would go next and then he would close out. So,
Mr. Bravo, again, whoever goes first will go last. If you would like to go first, I'll certainly ask Mr. Fallon if he's in agreement with that. Would you like to go first?
no, it's fine. You can continue on.
And that's just standard policy. That's nothing special for this case. Whoever goes first goes last. You understand that?
I understand that.
Mr. Fallon, are you ready to proceed?
Yes, Your Honor, I'd like to call my client as a witness.
And so you may do so. If you would stand so that you might be sworn, Ms. O'Rourke Bravo.
You solemnly swear or affirm the testimony that you're about to give in the matter pending before this court shall be the truth, the whole truth, and nothing but the truth?
I do.
And so what this means, since Mr. Fallon has decided that he's going to call a witness, is that you get an opportunity, Mr. Bravo, to cross-examine this witness, Ms. O'Rourke Bravo. You may ask her questions about anything that she testifies to. So if you want to make notes so that you will know the questions that you want to ask, you may do so. You understand that, sir?
Understood.
Mr. Fallon?
Thank you, Your Honor. Monica, has there been any domestic violence restraining orders entered in this case?
Yes, sir. There was a domestic violence restraining order issued in July of 2021, and it was a 3-year domestic violence restraining order covering myself and also covering both children.
What type of domestic violence did Mr. Bravo participate in against you and your sons?
Oh, stalking, threatening.
Can I rebut this testimony?
And so you understand that you will have an opportunity, Mr. Bravo, to ask questions of Ms. O'Rourke Bravo, just one second, about anything that she's testifying to. And then you will also have an opportunity to present your own testimony if you choose. You understand that?
Yeah, absolutely.
I'm sorry, I didn't hear that, sir.
Yes, I do understand. I was just curious, like, because we already rebuffed this domestic violence restraining order, are we going to have
And
to?
so, just one second. Mr. Fallon, I'm not sure that it's necessary to attempt to relitigate that. The court can take judicial notice that there was a restraining order issued on July, I'm sorry, I think it's the 24th. I was looking back, July 24th of 2021 that expired in July of 2024. Do you need anything more than that?
I thought the court might be interested in what type of domestic violence was perpetrated by Mr. Bravo, but if the court is not interested in that, then I won't ask any questions.
It has nothing to do with my interest in it. It has everything to do with me considering any domestic violence to be equal, and California case law indicating that the court can't grade domestic violence. It either is or it isn't.
Thank you, Your Honor. Okay, I withdraw that question then. How long
Thank you, counsel.
Thank you, Your Honor. How long have your children resided outside of the state of California?
Almost 2 years.
And they moved in November of 2023, is that correct?
Correct.
And what is the distance between California and where you reside in Kansas?
8 decisive factors will shape the outcome and the children's future.
1,500 miles.
tell me about the degree of financial hardship that you would suffer if the case is to stay in California versus transferring to Kansas.
In California, there is free legal help at the self-help desk. However, I clearly have to pay a lawyer to represent me. That is, especially the case since now in California, many of the hearings are in person. And I always have to appear via Zoom. In Kansas, there is an organization called Kansas Legal Services. It provides free legal advice to anyone. It's basically identical to the self-help desk. However, you can additionally apply for free representation as well. So in Kansas, the Kansas Legal Services is a nonprofit organization that provides free legal representation. So like lawyer representation in court. And so, both Mr. Bravo and myself, would have the opportunity to have the removal of financial hardship by having the case heard in Kansas, because there is not only opportunity for free legal advice, but there's also the opportunity for free legal representation. Whereas by remaining in California, I'm continuing to pay lawyer fees.
But can you afford to pay attorney's fees?
No.
Why not?
While Mr. Bravo works full time, I'm fully and permanently disabled, and so I'm on a permanent disability fixed income, which
What's
makes
your
it very
what's your
difficult.
monthly income?
It's about $3,000.
So paying for an attorney is a financial hardship for you?
It's a huge financial hardship, right? That I make less than $40,000 a year. Makes it very difficult.
Okay. Tell me about the nature and location of the evidence required to resolve the pending litigation. Where is the evidence that you would be utilizing located?
100%.
I'm going to stop you, but just 1 second, because I think we've all agreed that there's no pending litigation.
Okay. Well, I guess this hearing is pending litigation of a different nature. I'm talking about factor 6, the nature and location of the evidence required to resolve the pending litigation, including testimony of the child.
And so, counsel, there's no pending litigation.
Okay. Tell me about the ability of California courts versus the Kansas courts to decide this case expeditiously. How much time has it been taking in California versus Kansas?
The last time that the California.
And so, counsel, just 1 second, Mr. Wilson. I'm going to stop you again. I think you're asking this witness to speculate as to how long it would take in Kansas to hear a case of the same nature as the case in California. Not only is it speculation, but I think it calls for a legal expertise that this witness does not have.
Your Honor,
So the court's objection is this. She has another case in Kansas that she's having decided?
Well, she filed in Kansas to have the case transferred from California. So she has personal knowledge regarding how long it takes to get a hearing on calendar in California versus how long it takes to get a hearing on calendar in Kansas.
The court's objection is sustained.
Thank you.
Move on, counsel.
My next question involves a familiarity of the court of each state with the facts and issues in the pending litigation. Where have the boys been attending school for the last 2 years?
Kansas exclusively.
Have they been receiving therapy?
Yes, they have an individual therapist and family therapist. They are all located in Kansas. They are not legally allowed to see a therapist in California because of the therapy law, like the licensing things.
Where do they have coaches and teachers?
All of their extracurricular activities are in Kansas. All of their coaches are in Kansas. All of their music instructors are in Kansas. All of the majority of the people that they spend time with are in Kansas. Basically, everything and everyone they spend their time here, and the all of the like in the last hearing, all of the witnesses, all of the evidence that was presented, there were multiple expert witnesses that were presented, and they were all here in Kansas.
Thank you. Nothing further.
Mr. Bravo, did you have any questions for Mr. Rourke Bravo?
Yeah. You made the statement that you made. I believe you said about $40,000.
So Mr. Bravo, I'm
Can't
going
hear
to
it.
stop you for just a minute. Just 1 second, Mr. Bravo. I'm going to stop you for a minute. Something's happening with your sound. It sounds muffled. So we're having we're having difficulty hearing you.
Can you hear
So
me?
could you work on that for a moment?
Can you hear me or no?
Oh, it's much better now. So
Oh,
whatever
okay.
you've done, continue to do that, sir.
Okay, copy that. So the question with reference to you making $40,000 because you can't afford an attorney, I believe in the child support paperwork, you stated that you make about $2,000 from disability a month. Is that correct?
You are incorrect. I disclosed my finances, including all of the pay stubs from disability at the support hearing.
What is the amount that you make from disability?
I already stated that. It's
No, you have to answer the question.
$3,000 a month.
How much was it? I couldn't hear you.
So I already stated it's approximately $3,000 a month.
So 3,000 from disability, and then from child support you get 1,300. Correct?
Are you making, just 1 second. Thank you for making that a question. I know, Ms. O'Rourke Bravo, that you heard that question. And so the question was, so from child support, you're getting $1,300.
Yeah, I answered it. You maybe didn't hear my answer, but I did say yes.
Thank you.
And then from how much do you make from the business that you run out of your home?
Last year's profit loss was a couple $100 net.
So that's how much you reported to the IRS.
Yeah.
But that business, you can make money, like cash money, that you don't report to the IRS.
So that would be tax evasion. Are you asking me if I commit tax fraud?
Well, we did run that business together, so I have some sort of knowledge to
So
the.
just 1 second. Just 1 second. I'm going to stop you both because this is not a discussion. This is questions and answers. The question is,
Okay.
did you make money that you didn't report to the IRS? And you can certainly answer that if you would like, Mr. Rourke Bravo.
No, I did not.
So do you teach women how to make bras? What do you do for a business?
Objection irrelevant.
What's the relevancy of that question? What she actually does for her home business, Mr. Bravo?
I'm just trying to get to the. She says she makes $40,000 a year. If she's running a business out of her home, there has to be some sort of value to running a business.
The objection sustained. Ask another question, Mr. Bravo.
Okay. So what you report every month, is that the same that your statements, your bank statements would reflect?
Yes.
Copy that. So I'm just going to do the calculations based on.
Custody history weighs heavy, raising tension and deepening suspense.
The question first, when it's a yes or no, you have every right to explain your answer, but you have to answer first. So the question was, how many of your family members came to and testified at the hearing?
None.
And you gave an explanation for that, and the court accepts that explanation. Mr. Bravo?
How many of my family members showed up to the court?
2.
And who would you say took care of Ben and Sam as they were growing up?
I did.
How many of my family members took care of them?
Objection vague as to took care of.
And it's vague, so the court's going to sustain that objection. Try to rephrase it, Mr. Bravo.
Okay, how many of my family members provided childcare for our kids as they were growing up?
1 or 2 on rare occasions, very rare occasions. I was either not working at all or was working part-time for the entirety from the time the kids were born until we got divorced.
How many of your family members provided care for our kids?
None of my family lives in California. That's irrelevant.
And how many of your family members live in Kansas now?
Okay, it's gonna take me a second.
Like immediate family.
Just 1 second. Let Ms. O'Rourke Bravo answer the question that you've asked.
At the quickest count, somewhere between 22 and 25 of close family.
Where does your mom reside at this point?
Tennessee.
Where does your half-brother reside at this point?
Objection irrelevant.
The objection's overruled. You may answer if you can, Ms. O'Rourke Bravo.
I actually have multiple half siblings, and I'm not sure which one he's asking about.
Are you close to any of them?
Yes. I'm close to my half brother that lives here in Wichita.
On August the 22nd, did you know that I was making a visit to Kansas?
You had stated you were coming to Kansas to watch a football game.
I did not make that statement. What was it? It was the original reason.
I'm sorry, just 1 second, Mr. Bravo. I think you made a statement. I'm not sure that was a question. So don't do that again. Just ask questions.
Did on August, in June, I believe, late June, I sent you an email message stating that I was going to come out to visit the boys on August the 22nd for that weekend. Were you aware of that?
You sent me a message on June 22nd requesting visitation the weekend of August 22nd. I replied at that time that I had sent a message to you on June 1st that the children would not be available for visitation the weekend of August 22nd. I followed that up with 2 additional replies restating that the children that I had previously stated on June 1st that the children would not be available for visitation on August 22nd. And I provided multiple other options for visitation in July and in August for alternate dates for visitation, as we had previous travel plans that I had notified 3 weeks prior to your request that the children would not be available.
Were you aware that a flight had already been purchased and that I already had
So
taken?
I'm gonna stop you right now because I'm not sure what the relevancy of this line of questioning is. Just 1 second. I think it's relevant whether there was a visit and should have been a visit, but it's not relevant for the purposes of this proceeding for the court to determine which court should make those decisions.
Copy that.
Ask another question if you have one, sir.
Okay. Yeah, I don't have any other questions at this time.
Mr. Fallon, any other questions of this witness?
Just a couple. Now, since you've been there almost 2 years, have your children developed close ties to the state of Kansas?
Yes, sir. Very, very close ties. They're friends. They spend time with family here. They spend time with their friends here. They're deeply involved in school extracurricular activities. Both of them play club soccer and are on national level teams. So they're at soccer all the time. The little one is involved in music very deeply. They attend sporting events here. They spend time with cousins. We have family game nights with our cousins. We spend a lot of time with cousins. We spend a lot of time with my dad, their grandpa, who is currently on hospice care. Sorry. All of that to say, yes, all of their friends are here. And they enjoy their peer relationships here. They go over to their friends' houses. Their friends come over here. They spend a lot of time with friends. They have a lot of connections here. Yeah.
Will you be able to continue that lifestyle if this case the venue stays in California?
Answer the question. Short answer, no. Because of the difference in the laws and just the lifestyle and the for example, my oldest son, he starts work next week. Or this weekend. I'm sorry, this weekend. He actually got a job as a soccer referee. He's really excited.
How old is he?
13.
So he can't work in California.
He cannot work in California. No, but the like I said, the laws here are different. He'll be driving in a few months when he turns 14 because the driving age here is 14. And that's just one example of there's a lot of cultural differences that I don't believe that the California court would have full awareness of the kids' daily lives in the same way that a Kansas judge would. Additionally, there's
So right now, just 1 second, I'm going to object. It's going into a narrative, and I think it's non-responsive. The question is, if the case stays in California, how will it impact your ability to maintain your current lifestyle? That was the question.
Okay.
So let me ask it.
So just 1 second. So the court's objection is non-responsive and narrative, and I'm sustaining both of those objections. Rephrase, counsel, or ask a different question.
If the case were to stay venue in California, will you be able to afford to give the kids the current lifestyle that they're enjoying now in Kansas?
Oh, okay. I get it. No.
Why not? Why not?
I cannot continue to pay for California lawyer fees.
What
Bottom
about
line,
travel? What about travel expenses?
And travel expenses, right? It's a tremendous burden. Yeah, it's a tremendous burden. And having the case here in Kansas would relieve that burden for sure.
Nothing further, Your Honor.
Any further questions of this witness, Mr. Bravo?
Yeah, I do.
And I just need to advise you that you are limited to the scope of the questions asked by Mr. Fallon. You understand that?
Right. And then you just made the statement, or you said that you pay travel expenses to California. What's the exact value that you would say, how much it costs you?
It depends on how we get there. Airplane tickets are between $600 and $800 each. So there's 3 of us. So let's say 7 times 3, $2,100 for airplane tickets,
Is that for,
renting a car, and a place to stay.
She details hardship, past violence, and why Kansas must decide.
is that travel expenses to cover, to like attend court hearings, or is that travel to like for vacation?
I mean, I think the question was regarding court hearings. So if, or, coming out to California in for any reason.
And how
So
many?
the question now, just one second, the question now, is that travel expenses for coming to court? That was the question that you were asked, ma'am.
Yeah, so if to appear in court in California, that would be the travel expenses that I would pay.
Thank you, ma'am.
How much of that have you done in the past year?
At the last hearing, I requested to appear via Zoom. And then instead of paying travel expenses, I am paying lawyer expenses so that I have someone who is able to appear on my behalf in the courtroom.
You were doing that when you were.
Just one second. Again, Mr. Bravo, the question was, how much of that have you done in the last year?
And I said, I haven't traveled to California to appear at court in the last year because I have
I'm sorry, if you said that, I missed that. That
Yeah.
is certainly responsive.
Yeah.
Mr. Bravo, you have another question?
I do. Not really sure if I can ask this question, to be honest. Yeah, I think that's probably the skill, because I don't think I can ask that question. I'll leave it at that.
Anything further, Mr. Follen?
No, Your Honor.
And so, Mr. Bravo, now is the time for you to present evidence. You could testify yourself if you wanted to, or you could just wait and, just one second, and argue with the information that is already before the court. What would you like to do, sir?
I would like to testify.
So if you would please stand so that you might be sworn.
Do you solemnly swear or affirm the testimony that you're about to give in the matter pending before this court shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
You may proceed, sir. You just make your statement. If I object or if Mr. Follen objects, then you have to stop, wait for the objection to be heard, and then continue with your statement with whatever direction you've been given. You understand that, sir?
Correct.
You may proceed, sir.
So making some statements earlier, and this maybe a couple weeks ago, like August the 22nd, I did go and visit Kansas. I had informed Ms. Bravo that I was coming. I scheduled my visit as the court has asked me to do. I gave her a 48-hour notice, and I talked to the agency that does our child care exchanges. I let them know that I was coming. They tried to contact Miss O'Rourke. She said that she was not going to bring them. She told me in the email too that she was not going to, that the boys were not going to be available. I informed her that I was coming out because the court said that I needed to complete phase three of this new court order, which allows me to pick up the boys and be with them. I felt like, from my perspective, because of this hearing, Ms. O'Rourke was postponing my ability to see the boys so that she could get to this hearing to try to get jurisdictions changed over to Kansas, because I think she's thinking that Kansas court is going to be more lenient to her, so that she can change up our custody order. I am doing everything that the custody court, the custody order tells me to do. I have submitted paperwork in the past about Ms. O'Rourke violating the custody order. And again, I will be submitting documentation for another custody order violation. My intention is just to see my boys. And I want to be close to them. I want to see them. Ms. O'Rourke has not been flexible on the Zoom calls. This summer, they were on summer break. And, you know, I tried to communicate with Ms. O'Rourke to inform her that, hey, is there any way that we can change up the time so that I can get on the Zoom calls with the boys a little bit earlier? She tends to put the boys on like at 8:30 at night in Kansas, which I don't think is a good time, especially after like soccer practice and when they're tired.
And so I'm going to stop you. I'm going to stop you, Mr. Bravo, because this has nothing to do
Okay.
with whether or not
All right.
the court is an inconvenient forum. I'm
Okay.
surprised that there wasn't an objection as to relevancy. It
Okay.
just has nothing to do with the inconvenient forum. It has everything to do with your visitation, and but you're not telling the court anything that gives the court information about whether it should determine if this case should remain in California or be sent to Kansas, because both courts are very much capable of deciding those kinds of issues.
Okay. Sorry about that. I would say, in my opinion, it's just, it would be more of her stalling, being able to stall, changing jurisdiction would create more issues for me.
Objection, lack of foundation.
Well, the response would create more issues for me. So I think that he can testify as to what issues would be created for him. So I'm going to allow that.
So financially, it would create an issue in terms of the court system. I don't really know how to navigate the Kansas court system. I have visited the website. I have asked one of the clerks if there's like a self-help desk that I could tap into to be able to gain information and more insight. There isn't a self-help desk through the state of Kansas. In the Fresno County Court, there is a self-help desk, which makes it a little bit easier for me to navigate, to be able to understand how I can submit paperwork and to make sure that documents are correct and not going to be sent back to me. I believe if the jurisdiction is transferred to Kansas, it's going to make it a little bit tougher in terms of submitting paperwork and trying to get the paperwork into process so that I can navigate the Kansas court system. It's just going to be a little bit harder. So that's just my belief, though. And I honestly, I don't have the financial resources to navigate or to hire an attorney out there in Kansas. I'm already paying child support for $1,300. Obviously, I have my home and my cars and stuff that I have to pay for in my everyday life, which is pretty expensive out here in California compared to in Kansas. I think that's all.
Is there anything else, Mr. Bravo?
Huh?
Anything else, Mr. Bravo?
No, I don't think so.
Ms. Fallon, did you have any questions of Mr. Bravo?
Yes, quickly, Your Honor. Mr. Bravo, did you ever contact Kansas Legal Services?
I wasn't even aware of Kansas Legal Services. I just
He fears distance, financial strain, and losing his bond with his kids.
wrote it down right now.
Isn't it true that Kansas Legal Services would provide you with a free attorney in Kansas if the court were venued in Kansas?
I have no idea, sir.
Nothing further.
Any questions as a result of those questions asked of you, Mr. Bravo, by Mr. Fallon?
No.
And I said questions, I meant statement.
No, not at this time.
And so now I'll give each of you an opportunity to tell the court why the evidence that is before the court at this time would make California either not or either a inconvenient form, given the factors in Family Code Section 3427. Mr. Follen will go first, and then he will have the final argument. Mr. Follen?
Your Honor, California is clearly an inconvenient forum at this time. Kansas would be much more convenient for both parties. Going through the factors, number one, there was domestic violence in this case. That is undisputed. Number two, the kids have lived in Kansas for almost 2 years now. They have very, very deep ties in the state of Kansas. Their school, their extracurricular activities, a new job, their family, 22 to 25 relatives. They've sunk their roots down in Kansas now. The degree of financial hardship to the parties. Mother Monica is 100% disabled. It would clearly be a hardship for her to continue litigating in California. She just can't afford the attorney's fees. The evidence, any evidence in any future proceedings would be located in Kansas because it's all about the best interests of the children and their teachers and therapists and everyone relating to them that has anything to do with them is in Kansas now. They have no connection to California at all. The ability of the court of each state to decide the issues expeditiously. Monica's experience has been the Kansas courts have been faster, but in any event, the familiarity of the courts of each state with the facts and issues, that's pretty much the same. But overall, Your Honor, all these factors have been met. The financial burden is a huge one. It'll change the lifestyle of the children, the lifestyle of Monica if she's forced to continue to litigate this case in California. It's a crushing financial burden she's facing, and given the closeness of the ties and the roots that the kids have put down in Kansas, this case should be venued in Kansas, Your Honor. Thank you for your time.
Mr. Bravo?
It is my belief that the only reason this thing is coming up is just another way for Mr. O'Rourke to interfere with my relationship with our sons, to make it harder on me to maintain closeness with them. By changing jurisdiction, it's definitely going to make it harder for me to navigate, to be able to maintain my current relationship with our kids and stuff. Also, the brainwashing that has occurred with our sons. We talk about domestic violence and stuff. Like, there's been domestic violence on both sides that was definitely not reported and continues with my sons.
And so let me stop you, Mr. Bravo. You have to argue the facts that were in evidence, and you haven't put those facts in evidence in this proceeding that there was prior domestic violence from both sides. So move on, sir.
Okay. Just the violations of, can I talk about violations of custody orders?
You make the argument that you want to make, and if I find it objectionable, I'll object, or Mr. Follen may object.
As seen from the August 22nd visit to Kansas for me to see my sons, Mr. O'Rourke is not her intention is not to bring my sons and I closer. It is more to get in the way and to create a gap between my relationship with our sons. And honestly, I believe that the court should not allow for jurisdiction to be transferred, that they should allow me as a father to continue to be and have the ability to proceed legally. And also, as from our previous court situation, my family members showed up to our court hearing. They definitely have ties to California. I'm not really sure how Mr. Fallon got to the statement where they don't have any ties to California. But they have a lot of ties here. I have like over 30 members, family members here in California, in Fresno, that definitely would be close to our sons. They again have been stripped. They continue to be stripped from the ability to see them because of the move to Kansas and Ms. O'Rourke interference with my relationship with our sons. And so I just hope that the court does not allow this move to Kansas for the Butler County court system to take over jurisdiction, because this is just going to create another wall, basically, another headache for me and my family members to be able to see our son, or to see our family members.
Mr. Fallon?
Nothing further, Your Honor.
And so the court is prepared to take it under submission. I can rule as soon as next Thursday at 1:30. I'm not sure how that will impact the Kansas court. Judge Ricky, is that an agreeable date for your calendar?
Would you state that date and time again?
That would be September 11th at 1:30, or any time that afternoon. I could set it right at 1:30 or any time that afternoon.
I'm looking at my calendar and trying to find a hole.
Thank you. I appreciate that.
Unless my assistant vetoes this, I think that 3:30 our time, 1:30 your time, this would be a relatively concise ruling. I would think it would take no more than 30 minutes, I would trust.
I would
okay.
I would hope it wouldn't take more than 15 minutes.
Okay. At 1:30 California time, 3:30 Kansas time would apparently work on this court's calendar.
I appreciate that, Judge Ricky, and your clerk will make the arrangements so that we can all appear again. I can tell the parties, anyone who wants to appear in person in the California court may do so. Anyone who wants to appear by this Zoom will get information on how to do that. Mr. Fallon, I believe that you will be here at 1:30 on September 11th. Is that correct?
I was just going to tell you that I had a conflict, but then I saw the courtroom 304, so now I don't have a conflict. I'm going to be with you.
Okay, so we'll see you at 1:30. Anything further, Judge Ricky?
No, I think we'll go ahead and use the same Zoom numbers that we used today for simplicity purposes.
And we appreciate that.
And
thank you, Judge.
Okay, then I have nothing further at this time, Judge Allen Hill. And again, we'll plan on hearing your ruling 1:30 p.m. California time, 3:30 p.m. Kansas time on Thursday, September 11th.
Thanks, Judge.
Very well.
Thank you. Thank you, Your Honor. Everybody have a good day.
Thank you. Have a good one.
Closing arguments clash as both sides deliver their strongest blows. The judge delays the ruling, leaving the courtroom gripped in suspense. And that's it for today's case. Don't forget to like this video, subscribe to the channel,